I don't share the disappointment. So, my Democratic colleagues have repeatedly and rightly stated that President Biden did not assert executive privilege in the two cases before us. It's my understanding, though, that former President Trump did. What have the courts said on the question of whether or not a former president can assert executive privilege?
Well, first of all, I think thank you, Mr. Cole, and not only that, but Mr. Scavino's first letter engaging with the committee on November 5th, 2021 says that as well. And the ruling probably that you go back to, which is keep in mind that Trump v. Thompson was very narrowly tailored to the National Archives and not testimonial. And the question on whether a former attorney or whether a former president has privilege actually goes back to the Nixon case. And in very specific purposes for criminal prosecution, they say that can be waived. But the true answer to that question is, it should be ruled on by the court. Even the Nixon case has discrepancies as to what extent prior presidential privilege applies. But it's not nearly as clear as they would have you believe.
If a president, former or current, were to instruct an individual to invoke executive privilege, do they have any sort of legal duty to do so?
Yeah, I think in the numerous correspondence between Mr. Scavino's lawyer and the committee essentially says you put them in a paradigm of vagueness. Not only that, but because for twofold. One, the subpoena is significantly overbroad, but two, you're asking them to make a decision one way or the other in which they're potentially in violation of privilege or the committee's request.
Okay, and did the conduct and communications of the Select Committee allow for the individuals in question to be meaningfully prepared? And why would that be important? You touched on this a little bit.
Well, and this has been the case with all of them, but I think this one is even a little more interesting in that there's always the catch-all at the end where the committee says, we will ask about anything else, and anything you want to do, please provide a privilege log, which is just in contradiction to how this would go. But this one's really unique, particularly where we're at right now, because the original subpoena had 15 areas of inquiry. Subsequent correspondence that existed throughout the whole thing, about the only way in which the committee meaningfully responded was they expanded that to 33 areas of inquiry. They've never addressed the second subpoena. I don't know if the contempt rule, handles just the 15 areas that were originally subpoenaed, or all 33 now, but it's a pretty interesting place to be in when there's actually a subpoena issued and we expand the scope in the middle of that without ever addressing not only the overbroadness of the original parts, and also the additions, and now we're holding them in contempt. So it'll be interesting, I will say that.
In the report accompanying the resolution, did the Select Committee adequately demonstrate a sufficient showing of need and inability to obtain the information elsewhere? And why is that important?
Well, I think in a lot of, for a lot of this, and this again gets into the other side, but whatever they have said they would make available whatever wasn't in the National Archives. And in my understanding, there has been no meaningful engagement from the Select Committee on the other side of that.
It's my understanding on several occasions, the Select Committee continued to expand the scope of its topics that they wish to discuss. And one of the individuals named in the resolution before us, why is that problematic?
Well, one, because I'm not sure, either the contempt order only covers what was in the original subpoena, which is patently unfair to the witness because it has been expanded in the meantime between that, or it incorporates things that weren't actually in the underlying subpoena, and both of those I would think are fairly problematic for a future criminal prosecution.
And you touched on my last question a little bit, but I want to sharpen it a bit. Is the Select Committee acting in a manner consistent with the principles of congressional authority and inquiry, particularly as it seems they continue to suggest that they are all powerful and the final arbiters of any legal claim?
Yeah, the responses to this essentially is it's within the committee's jurisdiction. Current President Biden has not asserted privilege, and very little citation, very little backing for that, and very, very little meaningful engagement back and forth with somebody who is obviously trying to narrowly tailor and decide and get to the point of where they can provide what the committee is asking for.
Okay, yield back.
Thank you, Mr. Torres.
I have no questions.
Dr. Bridget, Mr. Reshnathala.
Thank you, Mr. Chairman. I appreciate it. Mr. Armstrong, to pick up